Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law, so please subscribe to our channel. If you have no assets and no kids, your divorce is going to be pretty quick. You still have to file a complaint for divorce. It still has to go to the clerk's office. It still has to be sent to a judge randomly selected who will then issue a summons. People still have to be served. So there are bones to the case, and every case is going to have certain of those bones. Having said that, because there are no children in the case, the court's not going to set up a timeline that's expanded over a minimum of 6 months like it would if they were kids. The life cycle in this case is going to be much, much smaller. Frankly, the life cycle could be 60 days, as soon as the court might invite you to finalize. So if you got no kids, you've got no assets, your case is really ripe for a quick resolution. So what you should be telling your lawyers is, and what you should focus on is, let's get this thing filed as soon as possible, let's get the other side served as soon as possible, and we can prepare a judgment. A lot of times here at the firm, when we have a case like that, we draft the complaint and everything, and we draft a judgment immediately, which basically says everybody keeps their own thing. The maiden name is restored if that's what they want to do. You don't owe him, he doesn't owe you, and goodbye and good luck. We can prepare a judgment like that and basically have it done nearly at the same time, just waiting for the court to say, gentlemen, come on in and let's get this done. So that's a possibility, a way to expedite it. But you got to remember, the drama and the time involved and the whole presentation before the court and all those things, it gets way more involved when you have assets and kids. Without that, you'll probably be spared most of that. Now, you might well have to go to court either personally or virtually in order to finalize that divorce, even if there's no assets and no kids. Because the court still has to verify that the statutory proofs are met and there's been a breakdown in the marriage, that you've lived in the state of Michigan long enough and in the county long enough in order to establish those basic minimum proofs. So you still have to have a hearing. But it'll be a much, much quicker proposition. If you have any questions about that, reach out and we'll be glad to help you out.